The designated hour having arrived, I call to order this regular meeting of Ansel Blink's Quorum Forum podcast, the podcast local governments need to do business. In the chair today, it's me, Erin Monforti, and on the agenda, we're live at the 2025 IAPD IPRA Soaring to New Heights Conference for regulating controversial park activities. So live audience, do me a favor, let the listeners hear you. Give us a cheer. Thank you. We normally do the session bright and early on Saturday morning, so you can imagine the coffee and the dread that comes with that. But it's Friday afternoon, and we're all really excited to be here with you today to close out our week at this great conference with you. So let's take the roll. First, we have an associate at Ansel Blink. He focuses his practice on election law and regulatory compliance, and has particular interest in environmental and employment issues. He's a Chicago sports fan, and we're going to ask him about it. Tyler Smith is here. Present?
Present.
All right, so Tyler, it's been a historical season for the Bears, but not in the way fans dream of. So the head coach was fired mid-season, making the first in-season termination of a head coach in Bears history. What are your thoughts about the recent announced replacement of Ben Johnson?
Very, very excited. The hope springs eternal once again in Chicago. The Bears weaken a division rival by stealing their offensive coordinator. Looking forward to see some of those high-flying trick plays next season.
Very good. I had to call in Google for some sort of sports question to ask Tyler. It's not my gig, but I'm glad he's here with us. And then we have a partner at Ansel Blink. She practices in a variety of legal areas within the firm as a civil litigator, zoning and land use attorney, and municipal prosecutor. She works with municipal, park district, and township officials and staff in drafting ordinances and resolutions, reviewing contracts and policies, drafting intergovernmental agreements, and attending board meetings. She enjoys golf and tennis, and we're going to ask her about it. Megan Mack is here. Hello. So, Megan, last year our session, and if all of you attended our session last year, you know we talked about the most controversial use in park history, and that would be pickleball. So as a tennis whiz, have you taken your talents to the pickleball courts?
As much as it pained me to like pickleball after all of the public hearings I sat through on it, I have found I'm way better at pickleball than tennis. And I don't know why, that I'm guessing smaller court, easier, you drink while you do it.
Lifetime activity.
A lifetime activity. It's also super popular amongst my age group, so I'll leave it at that.
All right, well, good to hear it from everyone. And as usual, our trusty engineer, Rick, is present, and we have a quorum. So today, we're talking about regulating controversial uses in parks, controversial activities, and our topics are e-scooters and e-bikes, First Amendment activities, and public camping. So we're ready to get started, and I'm going to pass it off to Tyler for a conversation on e-bikes and e-scooters.
Thank you, Erin. Now, while not as controversial as pickleball, e-scooters and e-bikes are something that are increasingly seen and adopted by many. E-bikes and e-scooters have come down a lot in price in recent years, and they're widely commercially available. And we're seeing a rapid spike in popularity, which is leading to tensions between patrons who might be wanting to ride e-bikes and e-scooters in parks and those who are riding traditional parks or just going out for a walk along public trails. We'll start by covering recent state legislation that provides park districts with increased regulatory authority over e-scooters and e-bikes, and then move on to some e-bike regulations, examples of regulatory approaches that park districts can take to regulate these vehicles, and finish up discussing how the recent state legislation presents some intriguing new wrinkles for tort immunity implications for park districts. The first thing that we're going to talk about is, as I mentioned, is the new state legislation governing e-scooters. Public Act 103-899 was passed by the General Assembly last year and became effective August 9th of 2024. And this act specifically provides park districts with greater authority to regulate e-scooter use on park district property, and it enacts new regulations for e-scooters under the Illinois Vehicle Code. The most important thing that this Public Act did was provide park districts and other local government units with the ability to decide whether or not e-scooters are going to be allowed for use on park district property. under this act, e-scooters are not allowed on Park District property such as trails, right-of-ways, highways, or roads under Park District jurisdiction unless the Park District takes affirmative action to allow the use of these vehicles on Park District property. Now, to note, this act defines an e-scooter as any device which weighs less than 100 pounds with 2 or 3 wheels and that's powered by either an electric motor or by human propulsion alone with a maximum speed of 10 miles per hour with and without human assisted propulsion. So depending on the specific characterizations of a device, it may not fall under a regulation of this act. And this act specifically does not apply to mopeds or e-bikes. The authority under this act just applies to e-scooters as defined under the act. Now, if your park district decides to permit e-scooters on your park district's property, there are some things that this act also does under the vehicle code, which already regulates e-scooters. So the two kind of categories of regulations this act enacted under the vehicle code is what we're going to define as kind of registration, operation, and then use regulations, which would be a lot like your standard moving violations for any traffic codes. Now, under this act, an e-scooter operator or owner does not have to have a certificate of title or register an e-scooter with the Illinois Secretary of State as they would for a motor vehicle. However, this act does provide that an e-scooter may not be operated under the influence of drugs or alcohol, and it requires that all e-scooters which are permitted on Park District property to be well maintained and in good operating conditions. So if you do allow e-scooters on your property and you notice that patrons are using them and they're not in a good operating condition such that the brakes don't work, they don't have front or back lights, kind of in the dusk and evening hours, that would provide your Park District staff or your Park District police officers, you have them with an opportunity to write citations under the vehicle code, kind of doing that and making sure that if you do permit them, they're in a safe, good operating condition to help ensure the safety of other patrons who aren't on such vehicles. Now, the next category of regulations that these act does under the vehicle code is some use regulations that will apply to anyone who is operating an e-scooter in the event it is permitted on Park District property. One of the biggest ones is that e-scooters may not be operated on any streets with posted speed limits exceeding 35 miles per hour. So any roads that are under your Park District's jurisdiction, which are leading into your facilities or your trails, someone cannot ride an e-scooter from their home up to the Park District if that posted speed limit exceeds 35 miles per hour. Additionally, e-scooters may only have one rider at a time when they're being used, and anyone who is operating an e-scooter must have 2 hands on the steering mechanism while operating it. So they couldn't be riding it and carrying things, or riding it and throwing a frisbee back and forth, or any of those kind of more dangerous activities that could jeopardize the safety of other patrons. And finally, one of the big ones is that e-scooters may not be attached to or pulled by another motor vehicle. So it's not necessarily would apply to trails, but someone couldn't use an e-bike to say and pull and tug someone along on an e-scooter, because some of the e-bikes do have greater engine capacity and can move faster. So that would be one thing that could present some serious jeopardy to other patrons in your facilities. The next class of vehicles that we're going to talk about is e-bikes, which are regulated a little differently than e-scooters under the state law and state legislation. Traditionally, under the vehicle code, e-bikes may be ridden on a roadway or pathway where bicycle use is permitted. So park districts don't have the same authority to prohibit e-bikes as they do e-scooters. As we saw a little bit earlier under the new legislation, e-scooters are only permitted when affirmatively authorized, but e-bikes are generally allowed where any bicycle use may be permitted. So you do have less authority to restrict the use of these vehicles. Under the vehicle code, there are 3 main categories of e-bikes. A Class 1 e-bike is defined as a low-speed electric bike equipped with a motor that provides assistance only when the rider is actively pedaling and cuts off when the bike reaches a speed of 20 miles per hour. Next, a Class 2 e-bike has a motor that can exclusively propel the bike without human-assisted propulsion and cuts off when the bike reaches a speed of 20 miles per hour. Finally, a Class 3 e-bike, like a Class 1 e-bike, has a motor that provides assistance only when the rider is pedaling, but cuts off when the bike reaches a speed of 28 miles per hour. So these vehicles, as you can see, have a little bit more top-end speed than e-scooters, which does present some issues considering that e-scooters at a lower speed can be blocked unless permitted, but e-bikes generally are allowed wherever bicycles are permitted. And Class 3 e-bikes, which cuts off when they have a speed of 28 miles per hour, is pretty fast. You can imagine if you're a patron just walking along a bicycle trail and all of a sudden somebody whips by you on the shoulder going 28 miles per hour, that could be pretty jarring, especially if it's late in the morning or early dusk in the hour and you're out enjoying a nice walk. So we can see why some patrons don't enjoy sharing these spaces with people who are using e-bikes and e-scooters in them as well. Now, while you have less authority generally to regulate e-bikes, as we'll see in the next few slides, which discusses your regulatory authority generally and then provides some examples of how Illinois park districts are regulating these vehicles, there is authority and you can kind of stop the use of these top-end Class 3 bikes is a very common approach if that's something your patrons are issuing complaints about. Now, under Illinois law, park districts as a special unit of government only can regulate or act when there's express authorization under Illinois law. And thankfully, we do have some strong basis that's codified for park districts to regulate e-scooters and e-bikes. Under the Park District Code, park districts have authority to manage and control all property that's owned and operated by the park district. So that provides a very strong basis for regulating the use of e-bikes. And, as mentioned earlier, under the Vehicle Code, local government units such as park districts have incredibly broad authority to decide whether or not to permit the operation of e-scooters. So if this is an issue that you're seeing with your patrons are complaining about the use or operation of these vehicles in your facilities and trails, you do have options to help ensure patron safety and engage and assuage some of these concerns. Now, we're going to go through the next few slides here and discuss some ways that park districts are doing it. For example, the Cook County Forest Preserve has taken a strong stance where they prohibit the operation of Class 3 e-bikes on park and forest preserve property. So Class 1 and Class 2 e-bikes are permitted, but the top-end Class 3 e-bikes with the high propulsion speeds topping out at 28 miles per hour are not permitted. Class 1 and Class 2 e-bikes are permitted on existing bike trails. Permission is needed to operate these vehicles in other areas of the forest reserve property. Additionally, e-bike riders must obey posted speed limits, and in the event that a speed limit is not posted, the maximum speed permitted is 15 miles per hour. And then additionally, e-bikes must yield to pedestrians. And these are just on the slide is just some of the brief ones, but the Cook County Forest Preserve's use regulations also require e-bikes to be ridden in single file on bicycle trails to help kind of prevent them from taking up space and taking up an entire trail, and prohibits riders from carrying another person on an e-bike's handlebars, frame, or fenders, which when some of these, even the Class 1 and Class 2 e-bikes can reach 15 to 20 miles per hour, having someone hanging out like on the handlebars, as you kind of would see from some normal kids on young kids riding bicycles at 15 miles per hour, tumbling or falling off that on a gravel path could cause some serious injuries, which is what that regulation is intended to prevent. Next, the Kane County Forest Preserve District is another example of a unit that has opted to prohibit Class 3 e-bikes while permitting the use of Class 1 and Class 2 e-bikes. The Naperville Park District has taken a more restrictive approach and only permits Class 1 e-bikes with max speeds of 21 miles per hour and requiring any patrons who are operating an e-bike on their property to be 16 years of age or older. Additionally, the Fox Valley Park District and Huntley Park District are examples of park districts that have also taken action in this area. Fox Valley presents one of the most restrictive approaches, which is prohibiting the use of motorized vehicles such as e-bikes and e-scooters on on all Park District property and limits the operation of any permitted vehicles to max speeds of 20 miles per hour. Huntley is also an example of this most restrictive approach, where they prohibit motorized vehicles on Park District property. Now we're going to discuss some of the interesting wrinkles that the use of these vehicles, if allowed, can present for tort immunity implications for Park District. As we saw, these vehicles can have much greater speeds than normal razor scooters or traditional bicycles, so the opportunity for injuries when they're being ridden on gravel paths or paved roads is much greater. Falling off a bike or a normal scooter, you might get some scraped knees, in the worst case, a broken wrist or fingers. But if you're falling off a vehicle that's moving anywhere from 15 to 28 miles per hour, the risk for catastrophic injury or great injury is highly increased. Now, to kind of frame this discussion, we're just going to quickly and briefly walk through some of the key terms for tort immunity for local government units. Under the Tort Immunity Act, a local public entity is provided a broad degree of protection and a shield from liability. This applies to park districts and forest preserve districts as local public entities. The Tort Immunity Act provides a broad grant of immunity against claims for tort claims and any claim seeking monetary damages. However, this is not an absolute shield. While it provides a broad degree of protection for tort claims such as negligence, it will not prohibit all lawsuits against a park district. Now, for the duty of care, this refers to what an injured party will have to prove in order to succeed on a claim. One element of a successful negligence claim is that an injured party must successfully prove that the park district owed them a duty of care and that the park district breached or violated that duty. If your park district does not owe the injured party a duty of care, then you cannot be liable for any injuries that party suffers while on your property. As a general example, if an injury is caused by a defective condition on park district property, such as a bike trail or recreation facility, a park district generally has a duty to maintain that trail or facility in a reasonably safe condition for intended and permitted users, and this is a key issue that we'll be coming back to very shortly. A park district will only be liable under a Tort Immunity Act claim when they have acted unreasonably under the circumstances, which is the general standard for a breach of duty under negligence. However, many of the immunities available to park districts under the Tort Immunity Act require an injured party to show that a governmental conduct is willful and wanton, such that actual or deliberate intention to cause harm, or if not intentional, conduct showing an utter indifference or conscious disregard for the safety of others. This is a much higher standard and is another example of how the Tort Immunity Act provides a broad shield against liability. Now, as I mentioned earlier, one of the key distinctions and issues under the Tort Immunity Act is that of permitted and intended users. The only persons a park district owes a duty of care to under the Tort Immunity Act is those who are intended and permitted users. And determining whether a given activity, such as riding e-scooters or e-bikes, is considered an intended and permitted use of park district property must be analyzed under a case-by-case basis, assessing the specific facts and circumstances of the injury. And now, this is the interesting wrinkle presented by the recent state legislation. So, what we see in the slide here, that unless specifically stated otherwise, in ordinance or resolution, jumping forward, the use of a low-speed electric scooter is not an intended use of a public right-of-way under Section 3102 of the Local Government Employees Tort Immunity Act. This language was ultimately removed from the final version of the legislation, but if it had remained included, it would have prevented any e-scooter rider who was injured on park district property from being considered an intended user, and this would have shielded park districts from any negligence claims by e-scooter riders who suffered an injury on the property. So, because this language was removed, there is a greater risk that if e-scooters are permitted, an e-scooter rider could be considered an intended and permitted user. But it's important to note that while this language was not included, e-scooter riders are not automatically considered intended and permitted users. it will still require case-by-case, fact-by-fact analysis of the specific circumstances of the injury. There's been recent case law on this topic from the Illinois Supreme Court, while not applying to e-scooters, but bicycle riders in the city of Chicago, that a bicycle rider was found not to be an intended user of a roadway because it wasn't a designated bike lane, even though there was a divvy station on the roadway. So while there is some concern about this topic, it's not a slam dunk case that every e-scooter rider will be considered an intended and permitted user. So there is still some ways to get out of any claims. And then we'll turn over next to Erin for First Amendment.
Thank you, Tyler. So today I'm going to go through some of the legal issues that arise when trying to regulate or manage the use of parks and park facilities as venues for First Amendment expressive activity, such as protests. From large demonstrations to smaller gatherings, protests and other First Amendment activities can present really unique and interesting challenges. So today we'll be talking about First Amendment protections, forum analysis, some of the permitted regulations that park districts can enact to regulate First Amendment activities, and then very briefly our favorite topic, which is First Amendment audits. I'll warn you that most of these topics could be covered in an hour themselves, but I'm open to questions and please feel free to ask. So I always like to point out that the use of parks are really interesting forums for speech because they're one of very few places that the Supreme Court has determined are traditional public forums for speech. And in this case that's shown here, the First District Appellate Court, which covers Cook County, and up north here says that the right to use and enjoy parks is a valuable right, and anyone who's wrongfully deprived of it may maintain an action to restrain his or her exclusion. So usually the tension we see when it comes to First Amendment activities in parks is someone's exercising their First Amendment rights by making a speech, passing out pamphlets, and then there's another group who claims that those activities are restricting their right to use and enjoy the parks. So this is kind of the tension that we see all the time, but kind of the underlying bottom line is that restrictions on access and use, how people are conducting themselves in park districts and other public areas, must comply with the First Amendment. So here it is. Here's the First Amendment. The Constitution looks really small right there. So, Congress shall make no law abridging the freedom of speech. And that's basic, but it encompasses so much. And I always like to point out, too, that, if you think about why the Constitution was adopted in the first place, it was to protect the rights of individuals vis-a-vis the government. So park districts and other units of government have a really unique role to play in shaping constitutional case law, and that's why we love being government lawyers, right? Megan and Tyler, we get to deal with complicated constitutional issues all the time. So types of speech. There are many different types of speech, but the common ones are written speech, which is pretty self-explanatory. If someone has pamphlets that they've printed out and they want to pass out at a park event or in the park on a lovely Sunday afternoon, that's written speech, and it's protected by the First Amendment. Spoken speech, it's what I'm doing right now. If I were standing in your park giving some kind of speech, whether it's political or not, that's First Amendment activity. Again, that's pretty straightforward. And these are the kinds of quintessential expression that we all think of when we think about First Amendment rights. It's speaking, it's leafleting, those kinds of activities. Symbolic speech is a little more challenging, and there's a famous Supreme Court case that kind of stands for what symbolic speech is. So some students in Iowa during the Vietnam War went to school with black armbands around their arms to protest the war, and they got disciplined, and I believe they were suspended for a few days after doing that. And they argued that their suspension violated their First Amendment rights because the band on their arm was political speech. They were protesting the Vietnam War. Ultimately, the Supreme Court agreed and said that there was no real disruption, that the school went beyond its regulatory authority in suspending the students for the symbolic speech that they had engaged in. Next, so we talked a little bit about this just a few minutes ago, but the forum analysis is really important. So when we just talked about what kind of speech it is it written, is it spoken, is it symbolic, then you move on to where is the speech activity taking place. And that kind of is where the regulatory authority of park districts and other units of local government starts to move and have some more dynamism. So this part of the puzzle is, it's important to consider where the expression is taking place. So the first type of forum we'll discuss is a traditional public forum, and it's places that are traditionally used for assembly, debate, and other expressive activities. So some examples that the Supreme Court has identified as traditional public forums: sidewalks, someone can stand on the sidewalk and speak their mind, and for better or worse for all of you, parks are a traditional public forum. So parks are one of those spaces that the Supreme Court has identified as a place where speech activities historically took place and that are covered by the First Amendment as forums where people can speak. So as recently as 2017, a court in Illinois determined that a park is a quintessential public forum. Designated public forums, so governments sometimes explicitly designate spaces as places where speech activity can occur. And the main difference between a traditional public forum, which has been historically open for speech activities, and a designated public forum is that in a designated public forum, there are some regulations you can enact based on time, place, and manner. Content-neutral regulations that can shape where speech is occurring and when it's happening. Lastly, a limited public forum. So as I always like to say that when you think about the different forums, it's kind of like a Russian nesting doll or like a set of concentric circles. So the traditional public forum, that's where people enjoy their broadest speech rights. The designated public forum, the government can step in and regulate more. And then a limited public forum, access is limited even more to certain types of speech. And so normally a good example for this is a courtroom. A courtroom is a limited public forum. Not everyone can walk into court, and if you're observing traffic prosecutions, for example, which is an interesting hobby, you can't just stand up in front of during the hearing as someone who's sitting in the court and start talking. The judge has the right to regulate and chair his hearing as he wishes. So why is this important? As I've said, a park, street, sidewalk is likely to be considered a traditional public forum. It's been announced as such from the early 20th century to 2017. And we like to advise that, being proactive in establishing policies and rules about what speech activities can occur when is really important. So the thing you have to remember if you are going to start regulating speech in designated or limited public fora, think about the time, the place, and the manner of the speech. Those are content-neutral factors that don't go to the content. It doesn't go to who's talking. If a group of protesters and a group of counter-protesters are kind of going at the same time, you aren't supposed to distinguish between the two when you're regulating what their speech activity is. But you can say, the parks are closed at 10 p.m. No activities of any kind can occur in the parks, including speech activities. And again, no regulations based on viewpoint or speaker. And so the government, including park districts, just need to be careful about restricting and regulating speech. If you've talked to your attorneys about speech activities before, you always hear content-based, content-neutral, prior restraint. These are terms of art, but really get to the heart of you shouldn't be regulating speech based on the speaker or what they're talking about, but you can regulate based on neutral considerations. So our first example today is an interesting one. So several years ago, Millennium Park is a beautiful gem in the city's cultural and green space collection. And the city views the park as a unique space because it showcases art, there are music events held there, architecture, landscape design. So when Millennium Park was founded and developed, the city enacted regulations for the park that differed from other Chicago parks. So for example, as you can see on the diagram, Millennium Park was broken out into several different outdoor rooms. So the different color coding kind of shows the rooms and what the spaces were intended for, what the spaces were going to be used for. And so part of those regulations restricted speech activities from patrons or visitors in different areas of the park. So just an example, you couldn't go to the band shell where a music concert or a concert was going on and pass out leaflets or stand up and interrupt the concert. And plaintiffs in this case, who regularly circulated petitions, who like to go there to evangelize and speak with people, were threatened with arrest by the Chicago police because their conduct in doing that during a concert or in the spaces that weren't rooms for public expression didn't meet the regulations. And so the plaintiffs sued, saying that the city had and the Park District had restricted their First Amendment rights. They had unconstitutionally violated them. So in the case, which was up on a preliminary injunction, the city tried to distinguish the park as a special space. It's not like other parks. It's more like Navy Pier. It's geographically distinct. It has a distinct purpose from most public parks because of its special use. And the court disagreed, hands down. So they issued the preliminary injunction to the plaintiffs and said, Millennium Park is a park. It is a quintessential public forum. And it's an open space and thoroughfare that people use every day. So you can't restrict speech activities like the city was trying to in that case. Permitting for speech. So when we have speech activities where the Park District provides permits, we get into questions about prior restraint, which are regulations that preemptively restrict speech. A permit is a prior restraint. If you're going to regulate when people can go and parade and protest, you have to be careful about how you do that. So keep the time frame for review and issuance very brief if you can. You don't want claims that you were restricting their First Amendment rights because you just didn't get to the application in time and they couldn't speak when they wanted to. Specific content neutral approval criteria. So if you're going to permit a parade in one of your parks, there are real safety concerns if there are floats and vehicles and people marching around.
Different height stuff, marking
Awesome.
fields.
Good to know.
Just neutral. Hopefully you're not applying different safety standards for different groups who have different messages to share. Being consistent with your enforcement, again, that goes to any potential First Amendment claims or discrimination claims. Frankly, you should be treating different groups neutrally with broadly applicable rules that apply to everyone equally. And then, of course, the fair considerations: traffic, safety, crowd flow, the pre-existing use of the park. So you don't, if you have the park reserved for something, or you have I know that some of our park districts just started having ice skating available because of the frigid temperatures. If you've got, ice ponds and someone wants to have a parade through the part of the park with an ice pond, not feasible, not tenable, and it's completely fine to regulate that way. And then noise. If your park is located in a heavily residential area, noise is a fair consideration for regulating as well. Okay, another example in City of Chicago versus Alexander. Chicago Park District sought to enforce the Park District Code, which prohibits people from being in the park from 11 p.m. to 6 a.m. Some Occupy Chicago folks were in the park and argued that, hey, we're doing this as a protest, we're exercising our First Amendment rights, we should be allowed to stay in the park. And the appellate court and Supreme Court disagreed in that case because the rule was content neutral, it was evenly applied. General regulations about park hours, which close the parks to everyone regardless of their use for a certain time of the night, are constitutionally fine. And Megan's going to talk about that a little bit more with public camping as well. But those are the types of regulations we see often, and they usually pass muster under the First Amendment. So briefly, I'm going to go through our favorite topic, which is First Amendment audits. And this comes up in the context of maybe protests and speech activity otherwise, because obviously in the wake of 2020 and some of the social movements we've seen in the last few years, the first thing people like to do is pull out their phone and record. So recording during demonstrations in public spaces is legal. It's not illegal for members of the public to record government employees or others in public spaces. And that's because people generally have no expectation of privacy in those spaces. Obviously, this might come up in different contexts as well. We get a lot of questions about, well, someone's going to the baseball game in our local park and filming the baseball game, but we don't think they're a parent or a grandparent, and it's kind of weird. And unfortunately, the advice we have to give is it's a public park, it's a public space, and people have free speech rights there, which includes the right to record. So our newest form of protest that we're seeing a lot, and we advise clients a ton on and do presentations on, are First Amendment audits. So these are encounters where someone comes to your facility with a camera and seeks to record employees doing their job and test whether or not they're going to violate the First Amendment. Usually they post it on social media. You might see some videos. And I always say maybe don't look up the videos. You're messing with the algorithm. But if they film someone doing their job, they ask them questions about where are your public records, how can you help me? They've got their cameras in the employee's face. And then after the encounter, they say whether or not the park district or unit of local government has passed or failed. And so you've probably seen videos like this, and maybe your park district has experienced a First Amendment audit. Our quick tips for responding to First Amendment audits, and like I said, this is a topic that could take an hour in and of itself, but what not to do. Again, as we've said, the right to record is a First Amendment protected right in public spaces where people have no expectation of privacy. Those are the two caveats. You can't tell the auditor to stop recording. You shouldn't threaten to call the police, because if you call the police and they show up, the audit will become twice as long because now they want to film the police officers as well. And the short and sweet is better, business as usual, and they will have nothing to post on social media that's interesting except all of your staff acting very professionally and according to Ansel Glink's First Amendment audit tips. Don't invite or let auditors back into restricted areas, so that might be employee locker rooms, other areas that generally do not include public circulation. People aren't walking back and forth. You shouldn't invite people back there because you could be opening a new forum, back to forums. Don't leave sensitive information out on a desk. Sometimes we've seen videos of people who are auditing trailing their cameras on documents with personal information, so park registration information. If Susie's mom calls you to register for something because she forgot to during the registration period, and you have her phone number and address, keep those things off your desk. I think that's also just a good risk management tool in general. Best practices. We recommend you remain calm, business as usual. Like I said, they won't get clicks and likes if you're just doing your job and everyone's kind of on the same page. It's cool, calm, and collected. You should empower staff. You should feel empowered if you are a staff member to call your supervisor who might have encountered a First Amendment auditor before or who has good training on how to deal with it, especially if you get flustered. I always say if I had a camera in my face, I would not be very pleasant at all. So, if you get flustered, have a cool-off period, phone a friend. Keep the encounter public. Secure private information in non-public areas, and you should be all set and ready to go. So I hope that was enjoyable for all of you. Next, we're going to be talking about public camping with Megan Mack.
Thank you. I'm going to add one more tip to that, what not to do under the First Amendment audit, and that's don't decide to then put your own recording device on the First Amendment auditor. I've seen that happen and it backfires tremendously. So we did talk about public camping last year. In the past, we've talked about guns, drugs, public nudity. Sorry, this year we're just coming back with more on public camping. So we talked about this last year with you, and we did think that the Supreme Court was going to take it up, and they did. And so we're here to follow up on that with you. So on June 28th of 2024, the United States Supreme Court did rule on the Grants Pass v. Johnson case that the enforcement of one city's anti-camping and ordinance does not constitute cruel and unusual punishment under the Eighth Amendment. And today we're going to discuss the legal background for the decision, the contents of the decision, the local responses, and we're going to also include a local response suggested by the Illinois Municipal League. But before we get to the Supreme Court's decision in Grants Pass, we should give you some important precedent. It started in 2018 with the Ninth Circuit prohibiting the enforcement of a public camping ordinance in the Martin v. Boise case. The ordinance there made it a misdemeanor to use streets, sidewalks, parks, or public places for camping. According to the Ninth Circuit, the Eighth Amendment's cruel and unusual punishment clause barred Boise from enforcing its public camping ordinance against homeless individuals who lacked access to alternative shelter. That access was lacking, the court said, whenever there is a greater number of homeless individuals in a jurisdiction than the number of available beds in shelters. And according to the Ninth Circuit, which is, mostly the West Coast, nearly 3/4 of Boise's shelter beds were not practically available because the city's charitable shelters had a religious atmosphere, and Boise was thus prohibited from enforcing its camping laws against the plaintiffs. So the city of Grants Pass, Oregon is home to roughly 38,000 people, and 600 of those are estimated to experience homelessness on any given day. Like many cities, Grants Pass passed an ordinance that restricted sleeping and camping on public property, parking overnight in public parks, and other related activities. And the penalties for violating these ordinances were on an escalating scale. So an initial violation of the ordinance could just trigger a fine. An individual who received multiple citations would be subject to an order that eventually barred them from city parks for maybe up to 30 days. And then the violation of those orders could eventually constitute maybe criminal trespass, and that eventually would then be punishable by a maximum of maybe 30 days in prison and up to a $1,250 fine. So the plaintiffs filed a class action on behalf of the people that were experiencing homelessness living in Grants Pass, claiming that the city's ordinance was against public camping, violated their Eighth Amendment rights, which is cruel and unusual punishment. The district court prohibited the city of Grants Pass from enforcing the law and applied the Martin v. Boise case, and that was the one that had to do with the amount of beds available in homeless shelters. The court found that the individuals in Grants Pass were involuntarily homeless because the city's total homeless population exceeded the practically available shelter beds under Martin, and the Ninth Circuit affirmed, and we talked to you about that last year. The Supreme Court held that the enforcement of generally applicable laws regulating camping on public property does not constitute cruel and unusual punishment by the Eighth Amendment. They did so in a 74-page opinion, in case you want to read it. First, the court held that the enforcement of generally applicable laws regulating camping on public property does not constitute cruel and unusual punishment by the Eighth Amendment. And think about it, cruel and unusual punishment, was originally brought up in the 1800s to address public flogging and hanging. Here, the fines and the jail terms have been and remain among the usual models for punishing criminal offenses throughout the country. Second, the court noted that the ordinances in Grants Pass do not criminalize the status of being homeless. And they talked about some similar crimes that people had discussed, or that California thought about enacting. At one time, California tried to legalize being addicted to drugs, and they weren't successfully able to do that. Now you can penalize people for being under the influence of drug, but you can't penalize people for their addiction. The public camping ordinances prohibit actions taken by any person regardless of their housing status, and that's what the court focused on. It makes no difference whether the charged defendant is currently a person experiencing homelessness, a backpacker on vacation, or a student who abandons his dorm room to camp out and protest on the lawn of a municipal building. So it wasn't specifically just targeting people who were experiencing homelessness, it was the actions themselves. The court did point to other legal doctrines and constitutional protections that might apply, such as the defenses of necessity, insanity, diminished capacity, and duress. States and cities may also add their own substantive protections. Since this legislation began, for example, Oregon has adopted a law specifically addressing how far its municipalities may go in regulating public camping. Third, questions of whether an individual is involuntarily homeless and whether a shelter is practically available cannot be found in the cruel and unusual punishment clause. And the Martin involuntariness test created uncertainty for cities, taking away the power from elected leaders to answer these difficult questions. The Supreme Court made a narrow ruling that the Eighth Amendment was not implicated by enforcing its anti-camping ordinances against individuals experiencing homelessness. However, anti-camping ordinances may violate other parts of the Constitution, like the excessive fine or the due process clause. In Illinois, we have other acts that we need to consider when we're talking about this issue. So first adopted in 1979, the Illinois Human Rights Act prohibits discrimination under state law for the same categories as the Federal Civil Rights Act. Additional protected classes were added over the years, including the prohibition on discrimination on the basis of ancestry, physical or mental disability, access to financial credit, and the availability of public accommodation. It is a civil rights violation for a public official to deny or refuse the full and equal enjoyment of the accommodations, advantage, facilities, or privileges of the official's office or services, or of any property under the official's care because of unlawful discrimination. A place of public accommodation includes places of lodging, public gathering, public transportation stations, and parks or other places of recreation. The Illinois Bill of Rights for the Homeless Act was passed in 2013 to provide specific protection for homeless populations in addition to the various state and federal constitutional protections. It specifically prohibits discrimination based on housing status and defines what municipalities can and can't do with how they handle their homeless populations. And some of the important protections include the right to use and move freely in public spaces, including but not limited to public sidewalks, public parks, public transportation, and public buildings. It also includes the right to equal treatment by all state and municipal agencies, the right to a reasonable expectation of privacy in his or her own personal property, the right to keep one's job, the right to access emergency medical care, and the right to vote. One of the terms you're gonna start seeing a lot in the wake of the new administration is reference to the Trust Act. The Illinois Trust Act declares that the federal government has the sole authority to enforce immigration laws. Local police departments can still enforce other laws against individuals who violate other municipal ordinances or state laws, but they cannot detain or arrest migrants solely based on their immigration status. We're starting to hear the Illinois Trust Act come up over and over again as school districts are now struggling with what's going to happen in the wake of a lot of the things President Trump is talking about. Park districts have certain regulatory powers that permit them to address how homeless populations can interact with parks. Districts must be careful, though, in passing any such ordinances to ensure they don't infringe on any of the anti-discrimination laws that we just discussed. Two key regulatory powers, though, that you do have under the Park District Act include the ability to establish your hours of operation and creating anti-camping ordinances. Both of these regulations have been addressed by the court. And then lastly, there is a model ordinance that the Illinois Municipal League adopted on public camping. This was adopted, drafted, IML in response to all this, drafted a model ordinance that regulates public camping. It contains multiple explicit references to the homeless crisis in Illinois. It makes clear that the legislative intent is to prohibit public camping by homeless individuals. Many municipalities do already have ordinances that impose civil penalties for camping activity on public property. However, IML's ordinance imposes possible criminal penalties with up to 6 months of incarceration. We caution you that singling out homeless persons for extraordinarily criminal penalties could impose municipal corporations to claims under the Illinois Human Rights Act and the Illinois Civil Rights Act and the Illinois Bill of Rights for Homeless Act, among other possible constitutional challenges. The Supreme Court's ruling in Grants Pass was strictly limited to a challenge based on the Eighth Amendment. However, the Grants Pass opinion itself recognizes that state law can limit how far municipalities may go in regulating public camping. One of the things I'd also caution you to keep in mind is you are talking within your park district about certain things that have to do with regulating public camping. If you find yourself in a position where you are having to remove someone because they are violating one of your park ordinances has, that you can regulate by hours and not public camping on your parks, is there are several cases that come from the city of Chicago that have to do with how you have to be respectful of a person's personal property. This comes up a lot if someone has been there and they have, maybe a tent or bags of clothing. Careful that if they have to be removed by the police, that you don't just toss all of their things, that you're careful that you preserve their items. You can find yourself in litigation because you destroyed their items as part of that. With that, I'm going to hand it over to Erin if we have time for questions.
We have plenty of time for questions. So, thank you all. And as you know, this is a regular meeting of the Ansel-Gilling Quorum Forum podcast. We do have to have public comment, and we're going to throw it to questions from all of you. So, if you have questions, please share them, and we're happy to answer. We just did such a good job. No questions.
Go ahead.
You said that we have to preserve their belongings. How long do we have to preserve them for?
I would say, I think the city of Chicago said like reasonable, it would be like a week. I would give them enough time that if they are being taken into custody, enough time for them to get out and come back and grab them.
Yeah, and that had to do with some sweeps on Lower Record Drive several years ago. And I think the city had just kind of performed routine sweeps and swept up a bunch of people's stuff. And so one of the constitutional rights that Megan talked about earlier, it's not just, the right to, or under the Bill of Rights for the Homeless Act, it's a right to have freedom in your personal possessions, and that kind of stems from the Fourth Amendment search and seizure clause. So you have to be careful, providing them, we've seen provisions providing access by giving them notice that you've seized their property, giving them an opportunity to come get it, giving them anywhere from maybe a week to 30 days to come get it before you throw it away or move it.
Everyone wants to go to happy hour?
I do have a question.
Okay.
So if they are staying at the campground and they leave, say they leave at checkout time, and they leave their possessions there, then how is that? So can I not remove them, or do I need to have a police officer remove them, or do I have to keep them for a week? How does that work?
Yeah, so the question is, and this is kind of for our audience on the podcast, so the question is, if someone abandons, even for just a night, their property in a park, can the park district or park district staff or the police remove their items if they've left them there overnight and they're not at their campsite in the park? Megan, do you have any thoughts?
So I think I would first look to determine whether they were abandoned purposefully, or if the person was removed differently. So if they were removed by the police and their stuff was left, I would hold on to their items longer. If you have more reason to believe it was abandoned, then I think you have less of an obligation. Does that make sense? You would have less of an obligation to preserve their things if you can make a determination that their things were abandoned.
Okay.
That they didn't intend to bring them with them, that's different. If they were removed by the police, then you have a greater obligation to hold on to them for them.
Part of the question was, they left during the day. Can they remove the stuff during the day, is that correct?
Yes.
They make a routine habit of leaving and then come back and forth.
Yeah, so I have, I have this a lot, where they will not pay, they don't have the means to pay for another night, so whatever they can't take with them, they leave. So am I obligated to keep that, and for how long?
Yes, I think you are obligated to keep that. I think you could notify them that they can't be keeping their things there. Give them notice of that, but I would not remove it after giving them notice that you're going to be removing their items.
So if I can't get a hold of them for some whatever reason and their stuff is still on that site?
I would hold on to it for at least a week.
Okay, so then I can actually remove it from that site and bring it into our facility and hold on to it? Am I,
I think you're fine to do that, I just wouldn't destroy it.
okay.
And I think that gets back to sort of what I was talking about as well, like with the neutrality of your regulations. If there are safety concerns with leaving personal items out in a park as well, you know, depending on what it is, you know, someone could ride their bike into a tent or so. If there are neutral concerns and it doesn't have to do with anyone's status or a condition of experiencing homelessness, then, you know, regular, neutral, equally applicable regulations can apply. But like Megan said, there are some restrictions on tossing or destroying someone's personal property, especially if you have an awareness that they are homeless. Those decisions are scrutinized really closely. Yes.
When this stuff applies to areas like playgrounds, does that differ? Where somebody has kind of taken up some space within a playground, and so now you have the community coming in and be like, what are we going to do here?
Sure. So the question was, what about a playground? You know, what if someone has taken up a camping site on or near a playground?
I think it's the same answer.
And we think it's the same. Megan is saying that she thinks it's the same answer for the same reasons. You know, someone's park, you know, rights to be in a park, their right to use and enjoy public property under the Bill of Rights for the Homeless Act, under what we talked about originally, which is that courts have decided in Illinois for many, many years that the right to use and enjoy a park is a fundamental right. That it doesn't really matter the extent to which where someone is in the park. You go ahead.
Totally get that. Now, what about when it's in a play structure that is not intended, like physically inside a structure?
Yeah, so the next iteration of the question is, what if someone's taken up space in a play structure, maybe like a slide, you know, or part of a playground where there's a tower where kids climb and stuff. Meg, do you have any other thoughts?
Is this during? Is this like during park hours or after hours?
It's sometimes a lingering thing. They might be there a couple of days. We don't get them.
So I think you could remove them, if your park ordinance states that you can't be there after park hours, then you're within your rights to remove them after hours. I think it's harder when you're during the park hours unless you have safety concerns. I think that's where it starts to get
with kids.
messier.
Yeah.
If you can truly make it a safety concern and you're not targeting them for being a homeless person.
Could you have them removed from that structure if the structure is made for a 5 to 12-year-old and it's a fully grown adult?
Does it say on the structure it's made for 5?
Yeah, there's stickers that you have to put on.
It's probably a valid safety concern then.
Yeah.
For the structure. And also for the safety of the other children not playing on it. Then I think that's more valid. This isn't the first time we've had these questions. Yes, I know it's an ongoing issue.
All right. We have a few minutes left. Does anyone else have any questions about maybe e-bikes and scooters?
Yeah,
Or
okay.
Oh, go ahead. Sure.
Sure. On the e-bikes and scooters, with as many diverse directions that districts or forest preserves can determine what goes on their trails, who has the main enforcement responsibility? Is it park police or forest preserve police or municipal police?
So the question was, if a park district does decide to permit or not permit the use of e-bikes and e-scooters on park district trails, what body or unit has the main enforcement authority to enforce those regulations, whether it be the park district police, if your park district has a police force, or the municipal police force. So it really would depend on your normal enforcement procedures for your existing park district rules and regulations. So park district staff are the ones primarily enforcing the rules and regulations for playgrounds or other recreation facilities. If staff are out patrolling, or if you have a park district police force that observes the unpermitted use of an e-scooter or e-bike on a trail, they would be free to enforce the park district rules and regulations. If you had a concern with maybe something under the vehicle code, where someone was riding in an unsafe manner, or the like, and you don't have a park district police force, your municipal police department would likely have authority to come out and write a citation for that as well.
If your park district has an intergovernmental agreement with your local police force, it's gonna be your police force. That would be my first inclination. It's probably your local police force, because there's not a ton of park district police. Oh, 1 minute left. Any last questions?
You could be on the podcast. Ask questions.
Do you want to be a celebrity on the F.Supp podcast? No takers.
All right, well, thank you all so much for joining us this afternoon. We hope you have a great rest of the weekend. Please join us for the rest of F.Supp sessions this afternoon, and although I guess tomorrow primarily. If you're still around tomorrow on Saturday, we're happy to have you. And before we go, we want to remind everyone to subscribe, leave the podcast a review wherever you hear it. We prefer good reviews. You can email us at podcast@answerlink.com, leave us a voicemail, and as always, you can visit us online at forum.answerlink.com. See you next time. Thanks so much.